Good to go. Good evening, everyone. Call to order the meeting of Board of Adjustment, City of Delray Beach, on January 18th, 2024. Diane, please call the roll.
Richard Kasser,
Present.
Seth Mitchell,
Present.
Aura Ramirez,
Present.
Jesse Slasser,
Here.
Brenda Cullinan,
Present.
Alec Hayes.
Here. Do we have any changes to the agenda? Can someone please make a motion to approve the agenda?
I'll make that motion.
I'll second it.
Agenda was approved.
I think we got to make the motion first, right?
Yeah, no motion was made with the second.
Okay.
Yes, so a roll call, please.
Richard Kasser,
Yes.
Seth Mitchell,
Yay.
Aura Ramirez,
Yes.
Jesse Slasser,
Yes.
Brenda Cullinan,
Yes.
Alec Hayes.
Yes. We do not have any meeting minutes to approve, but we do have a new item, which is adoption of bylaws.
Correct, Chair. So the bylaws, we try to adopt the bylaws again every 2 years. So this item is due, if you remember, at a recent city commission meeting, the commission gave direction that we could reduce the amount of time the board has to wait to determine if quorum will be present from 30 minutes to 15. That's truly the only substantive change within the bylaws.
This is just for our information. There is no voting on that, right?
Correct. That's a decision that was already provided by City Commission, so it's just informational purposes. And we will need a motion and a second and a roll call for this item as well.
Motion to approve?
Second.
Oh, no, so the chair
chair.
can't make the motion, so we need a motion from someone
I'll
other than the
motion to
chair.
approve.
Great.
Second.
Who made the motion?
I did.
Thank you. Richard Kasser,
Yes.
Seth Mitchell,
Yay.
Aura Ramirez,
Yes.
Jesse Slasser,
Yes.
Brenda Cullinan,
Yes.
Alec Hayes.
Yes. And now we're going to be moving on to swearing in the public. Please note that if you are planning to speak on any items tonight, you need to be sworn in.
Please raise your right hand. By the authority vested in me, the notary of the state of Florida, I do swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Thank you. Is there anyone in the public tonight who wishes to speak about the item that is not on the agenda? Right, thank you. We don't have any presentations today, right, William?
Correct, Chair. No presentations.
All right. All right, now I'm going to read quasi-judicial rules. This hearing shall be conducted in accordance with the City of Delray Beach quasi-judicial rules. The applicant and the city shall be permitted to present their case. The public should be allowed to speak for 3 minutes each, or a maximum of 6 minutes if the person represents an organization or a group of people who are present but agree not to speak. The board members, staff, and the applicant may be allowed to cross-examine a witness. The city or the applicant will be allowed to offer rebuttal testimony. The decision to approve or deny an application or appeal may not legally be made upon personal views as to whether a project is a good project or not, nor may a decision be based on the numbers of citizens who support or oppose a particular project. The law requires that all decisions must be made on the basis of whether the project meets the requirements of law, the comprehensive plan, and the land development regulations. Okay. Now we will be moving to hearing items. First item on our agenda today is 227 Palm Trail. Consideration of 2 variance requests to the standards of approval in land development regulations, section 797C, to allow a finger pier to extend from the seawall 33 feet 3 inches, whereas the extension is limited to a maximum of 25 feet. And section 7911A to allow a boat lift in the raised position to extend 38 feet, 1 inch from the seawall, whereas the extension is limited to a maximum of 20 feet. And the owners of the property are Mr. and Mrs. Spino, and on the city side we have Jennifer Booth today. Do we have an ex parte communication on this item?
No.
No ex parte communication. All right, then I guess we'll be starting with applicant's presentation and then follow with the city.
Correct, but I am Jennifer Buse. I'm a planner with the City of Delray, and I'd just like to put into file number 2024-027. And just to give you guys a heads up, upon my presentation, I realized that the file number is incorrect in the board options. So when you make your board options, make sure you look up at the screen. It has the correct file number. And the applicant is here.
Good evening, Chairwoman, members of the board. My name is Matthew Scott. I am a zoning attorney at the law firm of Greenspoon Martyr with an address of 200 East Broward Boulevard in Fort Lauderdale, Florida, and I have been sworn in. I'm here on behalf of Thomas and Laura Spino, the applicants. As stated, these are variance requests for a finger pier and a boat lift. First and foremost, for context, I want to provide a couple aerials. So, as you can see here, the property is located north of Atlantic Avenue on Palm Trail, on a particularly wide part of the Intercoastal Waterway. So then zooming in here, you can see the dimension is added, that in this area, the Intercoastal is over 300 feet wide. And so it's really important that I emphasize that in this area, I believe wakes are permitted. So this is not a no-wake zone. It's particularly important for why we're here asking for these variances, because the speed of boats is different than in other areas that are no-wake zones, where they must go slower and therefore can't create as many waves. Here are a couple site photos, and these site photos show what our hardship is. We have the burden of complying with your criteria for these variances and presenting evidence as to what the issues are that necessitated us seeking these variances. And so what these images show are just how low the water depths are, such that directly adjacent to their property, there is all this exposed rock, because in these areas, the water depths are between 1 and 2 feet, which is particularly low for this area and makes bringing a boat in and out of the property particularly difficult. This time I'd like to introduce our expert that's going to provide competent and substantial evidence as to the justification for the variances. And that is Tyler Chappelle. Tyler, I'll ask you to introduce yourself.
Sure, thank you. Tyler Chappelle, the Chappelle Group, 714 East McNabb, Pompano Beach. We're the consultant who did the design permitting of the dock and boat lift.
And Tyler, can you just share for the board your education and experience?
Yes, I have a BS in environmental science from Texas Christian University and have been doing dock permitting for over 20 years in the state of Florida.
And can you explain, using the image on the screen, what led you to design the finger pier and boat lift the way that you did, and what are the existing conditions in the area?
Yes, so the design for the boat lift and the finger pier was based on the two things: constraints for the location to the navigational channel and intercoastal waterway, as well as the depths at this location. We went through extensive permitting with the Army Corps of Engineers, FDEP, as well, the state agency that regulates seawalls and docks in the state of Florida and on the intercoastal waterway. And in the design modifications, going through that process, we originally had the finger pier and boat lift farther out in deeper water, but based on the Corps regulations and trying to adhere to their setback requirements for navigation, we were required to move the finger pier and boat lift to the current design distance from the edge of channel, the western edge of channel intercoastal, to allow for navigation and still allow for the boat to properly be able to moor at the residence.
So then, just for a non-expert like me, am I understanding correctly that what you're saying is that it would be even safer and more desirable to have the boat lift and finger pier go out further to the east into the waterway, but you weren't able to?
Yes, that's correct. The Army Corps requested that we move that finger pier and boat lift farther away from the channel to be more in line with finger piers and boat lifts along this section of the intercoastal on adjacent properties that had similar approvals. And also should be noted that even with that, the applicant's boat is going to have a difficult time getting on and off of that lift, even at low tide. It will be able to get on at high tide, but low tide will be difficult. And that's basically the farthest west we could go for the not only the boat lift to go up and down, but the boat to get onto that and still adhere to what the Corps requested of us in the modification.
So then, based on your experience, would you agree that the current dimensions that are being proposed are the minimum to safely navigate a boat in and out of this boat lift?
Yes, that's correct.
And then just one more question. The lines we see on the screen, can you explain what those represent? The markings that I see here?
Yes, so we had we had a bathymetric survey done of between the riparian lines to determine the depths. So those are the depths contours in mean low water. So that's the elevation at the average low tide, and you can see the numbers as they correspond. So it gets deeper as you go towards the channel, but up near the seawall and all that, you have the 1 and 2 elevation.
Great, thank you very much. All right, I'll clear that. So I always like to try to put things in, simple layman terms with these things, because a lot of the technical stuff can get confusing. What I believe we heard from our expert is that near the seawall here, the depths of the water are between 1 and 2 feet. And they don't get out till 3 or 4 feet as you get further and further away from the seawall. And so the proposed configuration is the bare minimum necessary to allow my client to enjoy the rights that all property owners along this waterway have, which is riparian rights and the ability to dock and store a boat or other marine structure at their property. And so this configuration was not something that we arrived at by choice, but rather by bare necessity, due to these weird, unique conditions here along this waterway, of it being a wide channel of over 300 feet that allows for wakes and allows for waves and more activity with the water. And then putting that together with the fact that right adjacent to their property, the water just really isn't very deep. It makes it very difficult to get a boat in and out of a boat lift. And so with that being said, this is the proposed configuration. Code permits a finger pier to go 25 feet from the seawall. We're seeking a variance to allow it to go 33 feet 3 inches from the seawall. Again, this odd dimension, you would expect it would be 33 or 35 feet, some clean number. The 33 feet 3 inches is driven by these competing issues of what the Army Corps dictated, saying we can't go out any further, and my client's expert trying to design something that would function at a bare minimum level. Similarly, we're proposing for the boat lift, which is affixed to the finger pier, to go out to 38 feet 1 inches from the seawall cap. Again, odd dimension here. That's the bare minimum that the Army Corps will permit, but will give my client a reasonable ability to bring their boat in and out of the property. And so again, here's an aerial just showing what we're seeking, just using an aerial. What I want to note at this time is my client did meet with the property owners on both sides of the property, and we have letters of support from both of them. They said that they were fine with this configuration and supportive of the variances that we're seeking. I will share that we had the boat lift in a different configuration than is being proposed, and in response to concerns from the neighbor to the north, we moved the boat lift to the south side of the finger pier to address their concerns, and that's what led ultimately to us getting the letter of support from that neighbor. And so here are, again, the variance requests. The variance request for the finger pier is a deviation of 8 feet 3 inches. And the variance request for the boat lift is a deviation of 18 feet 1 inches. Here are the letter of supports I just spoke about. They should be in your backup as part of the staff report. This is from the neighbors on either side of the property, so the north and south side. The only neighbors that realistically would be able to even see the boat lift from their property. And so I was candidly, pleasantly surprised that my client did the heavy lifting there and got those letters of support, because I've done this enough to know that makes it challenging if you have concerns from an adjacent neighbor next door saying you're going to block their view or something to this effect. So I'm happy we were able to resolve that prior to coming here tonight, seeking a variance from this board. And so the variance criteria, my burden here, why what I get hired for, is to explain how we comply with the criteria under your code. As the board chair stated in reading the quasi-judicial rules, this is a quasi-judicial hearing, right? And so you're sitting as a quasi-judge with your judge hat on, and you're tasked with reviewing the evidence and making a decision based on the competent substantial evidence presented in our application, in the backup, the staff report, and then testimony today. And so the first criteria is that there are special conditions and circumstances which are peculiar to the property. And so we showed you the bathymetric survey, and our client's expert spoke to how there are these competing issues with the Army Corps of how far we can go out, and then the odd lower water depths adjacent to the property that make it impossible to safely navigate a boat in and out of the property, which is something that all property owners that live on the waterway have a riparian right to, is the ability to dock and moor a boat behind their home. And so this is a special and unique condition that is affecting my client's property. The next criteria is that literal interpretation of the regulations would deprive the applicant of rights commonly enjoyed by other properties in the same zoning district. And so if the code is strictly applied here, if we aren't able to obtain these variances, it just will be impossible for my client to safely, on a regular basis, be able to bring their boat in and out of the property without having to worry about these low water depths and the waves and potentially damaging their boat, creating safety issues, trying to get the boat onto a boat lift. This is a common right, riparian right, given to property owners that buy properties along the intercoastal waterway. This is an easy one. The special conditions and circumstances have not resulted from the actions of the applicant. My client bought the property a few years ago and is currently building what is hopefully their final home. But they found the property in this condition. This was a surprise to them, and when they met with the permitting experts to say what sort of finger pier should we build, they were advised they've got an issue, and they're going to need to seek a variance if they want to safely store a boat behind their property. This is not something they created in any way, and it's just the existing condition behind their property. Next criteria is that the granting the variance will not confer on the applicant any special privilege that is denied to any other land structures and buildings under the same zoning. And so we're not asking for something that is not permitted. The code permits finger piers, the code permits boat lifts. What we're seeking is for the dimensions of those items to go further than code allows because of these unique conditions. And I would expect if there are other properties in the city on the water that have this depth issue, that they'd be able to come and apply for a variance just the same. And if they can meet the criteria, they'd be able to obtain a variance, showing that there are these, if they were to have unique conditions. Next criteria is that the reasons set forth in the variance petitioner justifies granting the variance, that the variance is the minimum variance that will make possible the reasonable use of the land, building, or structure. So this goes back to one of the questions I asked Mr. Chappelle. I said, is this the minimum? Would you want to do more? His answer was yes. A better design, from his perspective, was for this finger pier to go out even further into the waterway. But the Army Corps flatly would not permit that. And so, dealing with that tension point, the finger pier was brought back to the bare minimum design that could give my client the ability to have this finger pier and have a boat and get it onto a boat lift without always having to worry about these safety conditions and other related issues. And the granting of the variance will be in harmony with the general purpose and intent of existing regulations and will not be injurious to the neighborhood or otherwise detrimental to the public welfare. And so I think the fact that we met with the neighbors on either side and they provided letters of support speaks to this criteria. More importantly, there's really no genuine effect on any of the other neighbors by this finger pier based on the width of the channel here. It's not going to be not have any sort of impact on navigation in the area. Otherwise, the Army Corps wouldn't have given us the permit already. The other thing I would add is in areas around my client's property, there are some really old docks that go way further out into the waterway. Likely because they may have had a similar issue. I can't speak to that, but they've been there for a real long time, functioning without issue. And so that provides some circumstantial evidence that granting this variance will not be injurious to the neighborhood or otherwise detrimental to the public welfare. With that being said, I have questions. I'm happy to answer any questions you may have. Thank you for allowing me to make this presentation. And
Thank you.
Okay, good evening. This is 227 Palm Trail, and it is for two variance requests to LDR Section 797C, which allows finger piers to extend from the seawall at 25 feet, and LDR 7911 A and B, which allows the extension of the boat lift to go out 20 feet. So the property is a single-family resident. It's in the Palm Trail neighborhood, and it is zoned R1AA. So there are two requests, so you will vote two different times tonight, one for the finger pier and one for the boat lift. So the finger piers are actually under LDR Section 7.9.8, which are the standards of approval, and they have the same conditions as a dolphin, which is 7.9.7, and that's why we go back to the 7.9.7. And the boat lifts, B is included because in the upright position, the boat lift must be 10 feet away from your adjacent property lines. So a variance is a departure from the dimensional or numeric requirements of these land development regulations where such variance will not be contrary to the public interest and where, owing to the existing conditions peculiar to the property and not the result of actions of the landowner. A literal enforcement of the regulations would result in an unnecessary undue hardship. So there is a chart in here. It includes more than just the finger pier and the boat lift. I kind of wanted to give you a whole overview. The only two that are seeking the variance are the boat lift and finger pier. There is a dock. A dock is allowed at 5 feet, or 7 feet and 5 feet is proposed. A setback for the dock is 10 feet and 10 feet is proposed. So the finger pier is allowed to extend 25 feet and they are looking to go out 33 feet 3 inches, and the boat lift is 20 feet and they're looking to go 38 feet and 1 inch. The boat lift in its upright position from the north is 22 feet 6 inches from the adjacent property, and to the south it's 65 feet and 2 inches from the property. And this right here just shows you as well that there's almost 41 feet from the design to the edge of the water. You're only allowed one fixed dock is permitted per lot, and the dock shall not extend any closer to the property line. I just wanted to show here that the width of the property is 103 feet. Whoops. And the applicant has already shown you this. This is the mean low water hydrographic survey, and it shows, I've circled the number 2 as to where the 2 feet of water is. So before the finger pier is approved and it goes through building permit, it does, and this goes for all of our boating. It has to be approved through the Florida Department of Environmental Protection and or the Army Corps of Engineers. The Florida Department, FDEP, will state whether or not Army Corps of Engineers needs to be contacted for approval. And again, this is just showing where the boat lift originally was and where it has been moved. So if this is approved tonight, the applicant will just need to update the approval from the Army Corps of Engineers so that it represents what they are seeking tonight. This just talks about the riparian rights, and it is the rights to allow ingress, egress, boating, bathing, and fishing to the applicant or to the property owner. And here again, it's just showing 300 feet. For waters greater than 100 feet, a dolphin can be installed at 25 feet. Waters less than 100 feet is only 20 feet. And these are the findings. There is A through F, and it is up to the board to make a decision tonight as to whether or not the findings are met. And that concludes my presentation.
Thank you. Does anyone from the public wish to speak on this item? Please come forward.
I'm sorry, very quickly, there were letters of opposition that were emailed and are on the diocese, and there were letters of support as well.
Yeah, I believe one of those letters was mine. We also included some pictures of the neighboring properties. And I'm Theron Simmons. I'm an attorney. I represent Robert and Linda Kane of 301 Palm Trail. And I just have a brief statement. Won't take more than 3 minutes. We're discussing 227 Palm Trail, a request for significant implications for our community. It's a decision about more than just property. It's about the precedent it sets and the integrity of our zoning laws. The Spino's request lacks a key element, comparative depth analysis. How is the neighbor's property any different from theirs? That whole area has low water at low tide, and yet everybody else along that area makes it work. We even have a neighbor that has a Top Gun cigarette racer, which is like a 30-foot long boat that's parallel to the shoreline. So everybody else is able to get that to work, but for some reason, him and 219 weren't. Now, this board granted a variance to the neighbor. Now, when you start granting variances to everybody, it starts to look like zoning. And so I really think you should have that depth analysis to see if this is really any different than similarly situated neighbors. Their claim of minimum necessity also raises some questions. Many residents under similar conditions have managed without extensive alterations. It's essential to ask, is this truly the minimum necessary, or is this just about preference? And on that point of the variance, this is a special privilege if this board were to grant it. It would mark a departure from the norms we all adhere to, potentially inviting a chain of similar requests. If you've granted it to 219 and to the applicant, 227, why can't the next person down the road get it? And so that's why we have zoning laws. It's a collection, and if we want to change the zoning laws, there's a different method to do that. But this review of the variance request on a case-by-case basis, when they start to duplicate, it starts to look like zoning. Furthermore, there's undue hardship has to be present. What's the undue hardship? He can have a boat, I think, just like everybody else. Without the neighboring properties, depth analysis on the neighboring properties, you're going in blind without a depth analysis on the neighboring properties, not just north and south, but in the whole Palm Trail neighborhood. Finally, in closing, this decision is more about just dock extension. It's about maintaining the balance that our zoning laws are designed to protect. It's about ensuring that any changes we make are in the best interest of the entire community, not just the one property owner. Thank you for your consideration and for your commitment to upholding the principles that keep our community strong and harmonious. Thank you.
Thank you. Anyone else? All right. Is there any rebuttal or cross-examination from the staff?
Yes. Well, yes, just in case. Did you respond? she said staff. Okay, sure.
Because you know what we're about to ask, so you get.
Fair enough. I don't have any,
But you're allowed.
Madam Chairwoman, members of the board, I don't have any cross-examination. I just would like the chance to provide a closing statement or sort of rebut some of the comments.
We're allowed to do that, right?
Yeah, so you have no.
I have no cross-examination.
Okay. We don't, staff also does not, correct, Jen?
Okay, great. Thank you very much. So just a couple comments. I want to respond to the neighbor that raised some concerns. Let me see if I can. Okay. So I believe the neighbor is raising some concerns is the home that is 3 up from my client's property. And their property has a, give or take, 40 to 50 foot extension of land out into the waterway. And so I have no idea what the depths are next to their property. I have no idea the issues they faced. I also do not have data as to every other property along the waterway and whether they have depths issues or not. It's really important as sort of my closing statement here that I emphasize what it is that this board is required to review. And that is the evidence that's presented in my application. So the neighbor raised some concerns and said everyone has this issue. Well, there's no evidence for that. That's just a generalized statement. There's no way to know unless we were to measure every single property what the depths are next to their property to see if that's a generalized condition. And so putting that burden on my application just isn't what the law requires. Rather, I have a burden of presenting evidence that we have an issue unique to our property that justifies relief from the code. And so we've done that by having our expert get up and speak about the bathymetric survey they provided and how they studied the issues adjacent to my client's property. And so the standard being put forth by the neighbor simply isn't the standard. The only other thing I would add relative to the neighbor, I hear their concerns and I know maybe they don't like the variance, but this idea of a precedent is simply not the case. Your city attorney, I'll bet money, will agree with me here that there is no precedential effect to a variance. Every single variance under the law stands on its own because every property is unique. And so that this precedent fear or concern is simply unwarranted and is categorically not a reason to deny a variance. And so with that being said, we would respectfully request that these variances are granted because we presented competent substantial evidence that there is a genuine issue here that prevents us from complying strictly with code. And that based on this configuration, this is the minimum necessary to allow my client, the property owner here with these riparian rights, to safely navigate a boat in and out of their property and get it onto a boat lift. So with that being said, thank you very much for making this statement, and we would respectfully request approval.
Thank you. Now we will be moving on to board discussion. Let's maybe start from the right. Mr. Schlesser, any questions to the applicant or the city?
Can we come back to that, please?
I'm sorry?
Or come back to me, please.
Yes, Brenda?
I don't have any questions.
Yeah, so I believe that the applicant said that the pier and the boat lift are moving. They're shown on the north end, but they're being relocated to the south at the request of one of the neighbors.
Yes, sir, that's correct.
Okay. And in that move, because the property line is not a straight line, so the dimensions that are shown in that drawing, those are going to remain the same, just relocated south.
That's correct.
Okay. That was my only question.
Thank you. I guess my questions are mostly to the expert who applicant brought in. The depth, that's a minimum depth to have boat lift there. Does it depend in any way of the size of the boat that the boat lift will be servicing, or it's just for any boat lift to be able to be there?
Well, the boat lift itself has its own distance as far as the beams that lower the boat into the water and the depth, the distance that is. So that distance really doesn't vary that much. The beams get bigger as the boat gets bigger, but this size vessel, it's about 12 to 16 inches of clearance, and you need that for any boat lift, really. And the other configuration, what we did with this is that if you notice the orientation of the vessel is we did it bow in because the deepest of the draft of the vessel is towards the stern and where the engines are. So that's why we had it in this configuration too, so that the deepest part of your vessel is, and that's for any vessel really, is out towards the farthest portion of the finger pier.
So going with the smaller boat would not significantly change this distance?
No, you would still have a draft need for the boat lift, correct?
Okay. From your experience, is it possible that this minimum depth that's required would be so rapidly changed, literally within this 100 feet between one property and another neighboring property? Is that a possible thing that...
The only reason you would have that in this location, just based on looking at this area and having done some of the properties in this on the street, is that it's shallow throughout. The only way you would have a deeper portion is if that owner had dredged previously or had done, there was something done on that property before. But historically and through the aerial review that we did, this whole stretch of Palm Trail is more or less a shallow area. And that's caused, I don't know how it's caused, but you can tell the one property that's in question that it has the fill area out 40-something feet into the intercoastal. There's like a 90-degree turn in the seawall, so you can tell that south of that, there's accumulation of material south of that property. And so those residences are, have a shallower area.
Mm-hmm. This is not the first request like that we got. It's rather frequent that we have applicants in front of the board asking about that. So I guess what I wonder about is whoever came up with this minimum 25 feet from the seawall, I understand that they would take the current depths of water into consideration, right? I always wonder, is it because the levels of the water changed over the years that now we need to go farther with these piers and boat lifts, or it's just the demand for boat lifts and bigger boats occurred?
My experience is with a lot of these cities is that the variants or the way the codes are written are also, keep in mind that there's artificial canals that are in the jurisdiction of the city, and the majority of those codes or those provisions of those codes are based on that kind of constraint and not as much on the intercoastal side of things. The intercoastal is a different situation where you have a wider water body. You have oftentimes where it's not a no-wake zone in this situation, where in your artificial canals in the interior bodies of cities, you have a controlled speed, you have smaller widths, so there's more need for a constraint on how far you can go in and out of from your property. So a lot of times the cities, what they're doing is looking and revisiting the intercoastal waterways where you see the majority of the variances requests, because those are the areas where you need to get out, because you have and I'm going off base there, but the Army Corps and the Florida Inland Navigation District are the agencies that are responsible for maintaining the intercoastal waterway, and they dredge it, and you pay tax dollars to do that. But they only dredge the 125 feet and the side slopes of that channel. The channel's 300, so you have these shallower areas on the banks, and that causes people to have to go out farther to get to the depths that they need, regardless of the size of the vessel.
All right.
Ms. Hayes, if I may,
Yes.
the code was written in 1995, so it is quite old.
It's quite a while ago. I do not have any more questions. Seth?
So I was wondering if Mr. Stout, if you could just comment a little bit more about the wake zone versus not being a wake zone, and how that plays into having a finger pier and not having a finger pier. And then from the city, can you discuss the makeup of the rest of the intercoastal? Parallel parking or finger piers, please?
I can talk about the wake zone, sure. So as far as the need for a finger pier with this type of wake zone, it's more for the orientation of the vessel and getting onto the boat lift. When you have wave action that's coming, at towards the seawall or towards, parallel as the boat's going north-south, that wave is being displaced and pushed towards the east and west directions. So if you're trying to get on a boat lift, you're going to take that wave from the side, where it's better if you had a perpendicular type orientation where the boat can go up and down instead of like this, where you don't have as much opportunity for the boat to be damaged on the lift. And it allows the owner to be able to easily navigate into the lift better than actually to come in sideways as they're taking waves on the side, if that makes sense.
Yeah, that in speaking, we spoke about this today. If the variance is denied and the only thing they're able to do is a boat lift that's a pier and a boat lift closer to the property in an area where wakes are permitted, when they would be trying to get the boat on the boat lift closer to the wall where the depths are lower, the waves would rock the boat more and more and make it much more challenging and an unsafe condition, something that the expert here would not advise. And so that was the reason why we brought that piece up.
So to my understanding, there are similar boats that are the same size around it that doesn't require this.
So directly to the south, 2 homes down, is somebody that obtained a waiver in 2003 or something, or 2007. Yes, and that one goes out 50 feet, or give or take 40 to 50 feet. So I don't have the full history there, other than they asked the city for relief at the time because they must have had a similar issue. We don't have the data on what everyone else does or how they deal with it. As I said, the neighbor that has concerns, which we understand their right to disagree, they come out 50 full feet further into the waterway. So maybe they're able to get in and out much easier because they're 50 feet further out to begin with. And so I can't speak to what all the other owners do or relative to their sizes of their boats and things like this. I just know that there has been a history of some in this area seeking variances or relief otherwise.
So this is not, as her question, because of the size of the boat, right?
It's not driven by the size of the boat. No.
So I believe, Mr. Mitchell, you asked staff how often this happens, but I think to the point about a variance, that it's about the specific conditions on the specific property that you're looking at. So, we look at, when they do the lines on the topographic of the seabed and the depth, and we're evaluating that. In this, as the applicant testified, in this sort of stretch of the intercoastal, there have been other variances given, and this is the bump out that I think you were referring to. We process a lot of dock boat lift related issues, but they're case by case. So we're always looking at the water depth and the view impact of that particular position. So I'm not trying to give you a non-answer. I'm just trying to say that when it comes to a variance, it really is about your right to access the water. How wide is the canal or the intercoastal or the lake? We have at least one of each of those in play right now. And how will it affect the safety, the navigability, the neighbors, all of those things for the code. And I think to Ms. Hayes' comment, the code is written without any specific distinction among water bodies except for the navigable width. It doesn't speak to us about a difference on a lake versus the intercoastal, and so I can't give you. There's all kinds of different configurations, but they do respond to the depth of the seabed that is specifically outside of the property that has right to the water. So.
Thank you.
I have some questions now.
Can
actually.
I ask one more question?
Go ahead, please.
While I've got the floor? Thank you. This is for Mr. Simmons, if I may. Thank you. So, Mr. Simmons, can you specifically state what type of aggrievement your clients would have if this variance was granted?
It's going to be out of character with the rest of the neighborhood who are all parallel. So it's going to, if you're OCD, it's really going to bother you, right? Because now you got one perpendicular and everybody else is parallel. But besides that, everybody else makes it work. As the expert said, it's a shallow area, but everybody else makes it work. Finally, it's going to block the downstream view from my client's house, and really from everybody else's, because you're going to be blocking the downstream view towards the Atlantic Boulevard, right? And so that boat's going to be sticking out quite a bit further than anything else around it. Okay.
Thank you.
Thank you.
Based on this picture here, would it be reasonable assumption that that discoloration would be similar water depth all along there? And then, yeah, to kind of the brownish area right along the seawalls? I guess that'd be a question for the expert. And is there any way to know how far the dock extends out into the water? I can't see.
In
What
relate
is
to the
that?
brown area.
To 239 Palm Trail, the property to the north. And then is it correct that 209 Palm Trail to the south, that's the one that's 50 feet out?
And so I believe that 209, so yes, the lightness you see is why we're here.
Yes.
209, some 20 or whatever years ago, got relief to install what they did, which you can see is outside of that. The dock and the dock and pilings. Then the property directly to the north obtained a variance as well, but hasn't been constructed yet. I don't know the other dimensions though.
Okay. I'm just wondering, I don't know if anybody can tell, I have a hard time seeing, but do some of those docks not have boat lifts at all? I don't know who can answer that.
I mean, I don't want to guess,
Yeah.
and I don't know if it's
219 was proposed, I believe.
That's really it for my questions.
Is there any one of these neighbors that don't have a problem with this?
They seem to make it work
so that don't have a problem with what?
with the shallow.
With the lift and everything, with the water, with the boat?
Well, so the neighbor that's here today goes out 50 feet further into the water, and so
Right.
that they don't have an issue. We met with the neighbors on either side, and they provided letters of support for the variance, saying that they found that what we presented they're supportive of. But does anyone not have this problem? I don't know the answer. I don't know what they keep, if it's a jet ski, right? I don't know if they keep anything there, and so we don't have that information.
Okay.
I think you can see by the aerial that they.
I guess
It's relevant.
none of the aerials, and I have a map pulled up on this, but none of the aerials actually show boats parked in any of the docks or any of the lifts. So to take into consideration the downstream view issue that was brought up by Mr. Simmons, just in your time on the property, are there other boats that are parked or docked adjacent to, this lot?
Can we answer that?
Yeah, you can answer if you've seen anything. I don't know.
Yeah, I mean, the 2 times I've been there, I have not seen vessels at those docks. I know when we did 219, the neighbor just to the south of that, he had a boat tied up at the end of the L dock that he had received a variance for between the pilings and the L dock. But since then, that hasn't been there for quite some time. And then the L dock to the south of him, I've never seen a boat there. And then obviously 219, we requested a variance for a dock and boat lift, because of the shallow areas. So
And do you know the length of the dock at 236, the property to the north? Just approximate.
I'm trying to see.
that's I think they're talking about the finger pier that's coming.
239, excuse me. The finger pier on 239.
No, I don't know that. We didn't have it surveyed.
The only thing I will add, though, is that views are not protected. So someone who lives 4 houses away, 3 houses away, that's, in my legal opinion, not a lawful basis to oppose to deny a variance. Is the person's OCD and might not want to have to look at a boat.
They don't want to look at a boat? Is that what you're
So one of the board members was thoughtful enough to say, "What's your grievance?"
Right.
And the neighbor said, "Well, OCD, doesn't want to have to look at a boat." Respectfully, I get it. Like, I'm OCD about certain things. That's not, though, what we're here to consider, right, as you're sitting with your judge hats on.
It's not a grievance.
That's not a genuine grievance.
No, it's not a
particularly since they're
grievance,
3
no.
houses away. And they have the benefit of being 50 feet out further than my client.
That's not a grievance.
Do we have any more questions?
Mr. Scott, we see a letter in opposition from the Coppin family. Are you aware of that? Or
Yes, I'm aware of that, yes.
are they here to speak to their position?
No.
And I'm glad you brought that up, Board Member Mitchell, because these are unsworn statements, not subject to cross-examination. So other than them being a public record that's part of the file because staff received them, they really shouldn't carry any weight or evidence, the statements that are in them. Additionally, just a reminder, quasi-judicial rules state we do not make decisions on the amount of support or opposition to the project. And we're really looking at the 6 elements you guys have been presented.
Thank you.
We are going to move to board order.
Thank
Okay.
you very much.
So we have 2 variances. I'll begin with the finger pier board order. As a reminder, I will read the board order in full into the record. We'll stop after each of the 6 elements, and Diane will conduct a roll call. Pursuant to land development regulations, in order to grant a variance, there must be positive findings by at least 5 board members. The elements are written in a way that if you find that it's been met, then it's a positive vote of yes. So there's no trick elements in any type of double negative. So we'll start with the finger pier, and then we'll proceed with the boat lift request. This is file number 2024-027, dates January 18th, 2024. This is for the property located at 227 Palm Trail. The request is consideration of a variance to Land Development Regulation 7.97C to allow a finger pier to extend 33 feet 3 inches from the seawall. Pursuant to Land Development Regulation Section 2.411A5, following consideration of all the evidence and testimony, the Board of Adjustments for the City of Delray Beach finds as follows. 1, that special conditions and circumstances exist which are peculiar to the land structure or building involved and which are not generally applicable to other land structures or buildings subject to the same zoning.
Richard Kasser,
Yes.
Seth Mitchell,
Yes.
Ora Ramirez,
No.
Jesse Slusser,
No.
Brenda Cullinan,
Yes.
Alec Hayes.
Yes.
2, that literal interpretation of the regulations would deprive the applicant of rights commonly enjoyed by other properties subject to the same zoning.
Richard Kasser,
Yes.
Seth Mitchell,
Yes.
Ora Ramirez,
No.
Jesse Slusser,
Yes.
Brenda Cullinan,
Yes.
Alec Hayes.
Yes.
3, that the special conditions and circumstances have not resulted from actions of the applicant.
Richard Kasser,
Yes.
Seth Mitchell,
Yes.
Ora Ramirez,
No.
Jesse Slusser,
Yes.
Brenda Cullinan,
Yes.
Alec Hayes.
Yes.
4, that granting the variance will not confer unto the applicant any special privilege that is denied to other land structures and buildings under the same zoning.
Richard Kasser,
Yes.
Seth Mitchell,
Yes.
Ora Ramirez,
Yes.
Jesse Slusser,
Yes.
Brenda Cullinan,
Yes.
Alec Hayes.
Yes.
5, that the reasons established in the variance petition justify the granting of the variance, and that the variance is a minimum variance that will make possible the reasonable use of the land, building, or structure.
Richard Kasser,
Yes.
Seth Mitchell,
Yes.
Ora Ramirez,
Yes.
Jesse Slusser,
Yes.
Brenda Cullinan,
Yes.
Alec Hayes.
Yes.
And 6, that the granting of the variance will be in harmony with the general purpose and intent of existing regulations, will not be injurious to the neighborhood or otherwise detrimental to the public welfare.
Richard Kasser,
Yes.
Seth Mitchell,
Yes.
Laura Ramirez,
Yes.
Jesse Slusser,
Yes.
Brenda Cullinan,
Yes.
Alec Hayes.
Yes.
So as a board, you have determined that the applicant failed to establish that special conditions and circumstances which exist are peculiar to the land structure or building involved, and which are not generally applicable to other land structures or buildings subject to the same zoning. And the board has also found that the applicant failed to establish that the literal interpretation of the regulations would deprive the applicant of rights commonly enjoyed by other properties subject to the same zoning. This time, since the board has determined that those two elements were not met, it would be appropriate for the board to make a motion to deny the variance request for the finger pier.
Anyone would like to make a motion?
I'll motion to deny.
Do second?
Richard Kasser,
So
Was there a second? I'm sorry, I didn't, okay.
Yes.
yes.
It was.
So, I'm sorry, Board Member, go ahead and answer, you had a question?
yeah. So a vote yes is a vote to deny.
Correct. And that's based upon the board collectively determining that they failed to establish the two elements that I read.
Richard Kasser,
Yes.
Seth Mitchell,
Yes.
Laura Ramirez,
Yes.
Jesse Slusser,
Yes.
Brenda Cullinan,
Yes.
Alec Hayes.
Yes.
So we'll read the second board order to allow a boat lift. This is file number 2024-027 for the Board of Adjustments hearing on January 18, 2024 for the property located at 227 Palm Trail. The request is consideration of a variance to Land Development Regulation 7.911A to allow a boat lift in the raised position to extend 38 feet 1 inch from the seawall pursuant to Land Development Regulations Section 2.4.11A5. Following consideration of all the evidence and testimony, the Board of Adjustments for the City of Delray Beach finds as follows. 1, that special conditions and circumstances exist which are peculiar to the land structure or building involved and which are not generally applicable to other land structures or buildings subject to the same zoning.
Richard Kasser,
Yes.
Seth Mitchell,
Yes.
Laura Ramirez,
No.
Jesse Slusser,
No.
Brenda Cullinan,
Yes.
Alec Hayes.
Yes.
2, that literal interpretation of the regulations would deprive the applicant of rights commonly enjoyed by other properties subject to the same zoning.
Richard Kasser,
Yes.
Seth Mitchell,
Yes.
Laura Ramirez,
Yes.
Jesse Slusser,
Yes.
Brenda Cullinan,
Yes.
Alec Hayes.
Yes.
3, that the special conditions and circumstances have not resulted from actions of the applicant.
Richard Kasser,
Yes.
Seth Mitchell,
Yes.
Laura Ramirez,
Yes.
Jesse Slusser,
Yes.
Brenda Cullinan,
Yes.
Alec Hayes.
Yes.
4, that granting the variance will not confer onto the applicant any special privilege that is denied to other land structures and buildings under the same zoning. Neither the Diane.
Richard Kasser,
Yes.
Seth Mitchell,
Yes.
Laura Ramirez,
Yes.
Jesse Slusser,
Yes.
Brenda Cullinan,
Yes.
Alec Hayes.
Yes.
5, that the reasons established in the variance petition justify the granting of the variance, and the variance is a minimum variance that will make possible reasonable use of the land, building, or structure.
Richard Kasser,
Yes.
Seth Mitchell,
Yes.
Laura Ramirez,
Yes.
Jesse Slusser,
No.
Brenda Cullinan,
Yes.
Alec Hayes.
Yes.
And 6, that the granting of the variance will be in harmony with the general purpose and intent of existing regulations, will not be injurious to the neighborhood or otherwise detrimental to the public welfare.
Richard Kasser,
Yes.
Seth Mitchell,
Yes.
Laura Ramirez,
Yes.
Jesse Slusser,
Yes.
Brenda Cullinan,
Yes.
Alec Hayes.
Yes.
As a board, you have determined that the applicant failed to present substantial competent evidence that the special conditions and circumstances that exist, which are peculiar to the land structure or building involved, and which are not generally applicable to other land structures or buildings subject to the same zoning. As with the first one, as a board, you've determined that element was not met. Advise a motion to deny the application.
Motion to deny?
Second.
Richard Kessler,
Yes.
Seth Mitchell,
Yes.
Aura Ramirez,
Yes.
Jesse Slesser,
Yes.
Brenda Cullinan,
Yes.
Alec Hayes.
Yes.
And Chair, that concludes the board orders for item 8A.
All right, and now we will be moving to item B, 825 Southeast 7th Avenue, 2024-028. Consideration of a variance request to LDR Section 7911B, boat lifts, to reduce the setback for a jet ski lift with the vessel in its raised position from a minimum of 10 feet to 4 feet 2 inches on the west and 0 feet on the east. Do we have an ex parte communication on this?
Yes. I've spoken with a member of the public in the audience here on this matter, personal family friends and clients of mine, and one of them has written a letter to the board, so I'll be abstaining.
Thank you. Anyone else?
Very briefly, so under the Florida law, if you do not have a conflict, generally you have to, you're obligated to vote on an item. If a conflict generally is if there's some personal benefit that you'll be gaining by voting on the item. So
By voting on the item, no, but I just felt that it was biased.
okay, so there is a provision that if it's a quasi-judicial hearing, which is what this hearing is, and you feel that there's an appearance of impropriety by your participation, you can elect not to participate even if it doesn't rise to the level of a conflict. And it sounds like that's what you're communicating.
Yes.
Okay, so if that's your decision, then you'll need to leave the chambers just as if there was a conflict.
Okay.
So generally, the members will go to the antechamber, which is a small room in that back corner.
Just back this way?
Correct.
Okay.
Thank you. And now we'll be moving with applicant's presentation.
Yeah. Good evening, board members. Julian Gudanik, Senior Planner. Before I turn it over to the applicant, I just want to enter into the record file number 2024-028. Go ahead.
Hi, my name is Akbar. I'm the contractor for both lifts of South Florida. I'm speaking on behalf of the homeowner, Vigario. We requested a proposal to install a 12 by 13 platform jet ski elevator lift for his property. We requested a variance because of the unique plat of his land, which put a very severe limitation of the 10 feet setback waivers. So we requested two waivers from the left side and the right side. As you can see, his total waterway property is 24 feet with some inches. It's very, very small to try to find a wiggle room as much as possible. They used to have a dock and a jet ski floating platform, and they got rid of it. It was really big. So we tried to find a way to fit and minimize it. So the best solution we can find without having to need to put our pilings in or take as much space as to put a elevator lift for the platform on it. So that way they can have two jet ski lifts on it. And the jet ski will stay within the platform and not go encroach outside the space. And the platform stays inside the riparian white line. And because of the jet ski, they get acid easily coming from the left side into the platform. And we are proposing the platform elevator because of the water they have. The cap is in higher elevations, and the water level is just very, very low. So it's a very high drop. So for them to put a floating platform, it creates a bigger risk of them falling into the water, injure themselves, or falling into the floating platform and hurting themselves. So you can see it in the survey. We have the legal description with our represented right line on the north side, the east and the west side, and it's a very tiny little wiggle room. So we try to keep it inside, which states that they are allowed to use their pleasure within the area, so not go over to the neighbor property side on the right line. So it stays within their white line, and in that area, because of the corner space, they should be allowed to have a boat lift, because each property are entitled to have a boat lift installed. But a part of it is setback waiver. It's very hard for them to find a way to not encroach into other people's property line. So the best solution we can find, by giving them most spaces they can for the south and the north side, is to put in that specific location where it doesn't affect anywhere. Actually, you can see the picture. If you look at the right here from across, you can see the neighbors on the east side, it sticks out that way, and then the neighbors on the left side it's a very tiny little corner. So we try to be mindful of people around it, while you can figure out how to safely moor the vessel entree. Not to mention that it's right on the intercoastal, so the wake zone is a bigger concern, especially when you're on a low tide and the shallow water is sort of feet deep. So the way elevator and the high tide, the jet ski can actually safely come out or come in, but a low tide is create a bigger risk, especially when a jet ski bed is sitting on top of the sediments. And the way water come here, it has damaged the jet skis. So the best solution for us is to be able to install the jet ski elevator, so that they can have a sense of a dock, but not have a dock, but also have a lift. So the jet skis are typically 10 feet long, and the elevator is have a 12 feet long with a 10 feet arm, which would be perfect fit for a jet ski, and it can hold 2 jet skis at the same time rather than have to have one individual lift for one individual jet ski. So it holds 2 jet skis, and it has center stacking. It's safer for the kids or any elder person to safely board on the jet ski and not have to worry about the dangerous rate that comes in that causes them to be out of motion. So it's much more stable coming in and out of the water. And also, another bigger thing is because it's such a small area, it is very hard to dredge the area, especially when you have a dolphin pilot in front of you and other people around. So for them to ask the boss to come here to dredge the area, it's not that much of a wiggle room. We try to figure out the best option. We already have approval from Army Corps and Florida DEP stating that they're authorized to allow to install the jet ski platform there within in the coastal area. As you can see, the whole function, you can see it's a very small area. They installed a new CO elevation. It's much higher. It's almost to the same elevation as the north side, and it matches the same elevation on the right side. So it's because it's higher. You can see how big of a drop into the water, and it's because it's shallow water, they can actually injure themselves if they fall in the water, if they're having some sort of safety feature underneath for the jet ski. So it's not really that much of an option that we can go with. So a measure for the top of the cap to the bottom of the water, so 7 feet, and then you have 2 feet of water, that's 6 feet drop of nothing, and then you hit the water. You know how you hit the water, it's solid, and then you hit the sand. It's just too much of a huge risk factor to have something that's so low, and you have a ladder. And before they had the house before that they were emanating, the CO cap was much lower. So for them to, they would be able to get rid of it because it's not a much big drop, but now it's higher elevation. To keep up with the flooding, so especially the king tides and so on, so it saves them to have a higher elevation cap, but you have to meet with them in the halfway points to have a jet ski elevator. So it's the same common problem with the cove and the north side and south side, the corner property, they both have docks on it, but because it's such small spaces, they're able to have a dock there, so they should be able to have something on it rather than just a cap. So we try to do as much as we can to minimize the impact of the waterway. That's for now.
Thank you.
Good evening again, board members. Julian Gdanek, Senior Planner. We're just going to go briefly over the facts of the situation. The applicant's representative gave a thorough overview, but I just want to touch on a few other things as well. Firstly, some site information for some context. Lot size is approximately 1/4 acre. It's existing single-family residence. It's a low-density land use designation, and the zoning district is R1 AA single-family zoning. This is an aerial view of the subject property. You can see it sits on the intercoastal. It's a little bit of a unique configuration. We'll get into that a bit more when we talk about the plat. These are the adjacent properties. For context, the red star highlights the subject property under consideration. The left side is facing east, and then the right side is facing north. And then this is the subject property. The red square or rectangle indicates the area of consideration this evening. And just one more aerial view. So the request before you is consideration of a variance to LDR section 7911B boat lifts to reduce the setback for a jet ski lift with the vessel in its raised position from a minimum of 10 feet to 4 feet 2 inches on the west and is 0 feet on the east. Before I dive into the site plan a bit more, I just want to give an overview of what the code requires or what it allows in terms of boat lifts. Boat lift may be permitted subject to the following conditions. A, the boat lift in a raised position shall not extend more than 20 feet into the waterway from the property line or the seawall or bulkhead, whichever is near to the waterway. This proposal complies with that, so that is not an issue. Letter B is where the concern is. When plot frontage exists along a body of water, only one boat lift is permitted. Again, that's not an issue. The boat lift shall be located so that the vessel in its raised position shall not extend any closer to the adjacent property line than 10 feet or the building side setback, whichever is greater. In this case, that's 10 feet. So the plan that was proposed does not comply with that code provision, hence why they're here before you today for some relief consideration. I've highlighted in red circles the two setbacks. The setback is measured at a perpendicular 90-degree angle from the property line at the point where the dock or the lift is closest to that property line. So in the case of the west side, which is the larger circle, that's the 4 feet 2 inch setback. That's at the closest point. And then on the other side, that the 0 foot setback is actually in the right of way. So it's measured off of the sort of extension of the property line into the waterway, but that's the point where the dock is at its closest. Again, 0 feet, and then 4 feet 2 inches the other side. Because there's a lot of lines going on, and I wanted to just highlight this to provide clarity. The blue line is the property line, and then the green hashed line is the extension of that property line into the waterway, which is also the riparian rights line. And then this shows the setback in relation to those two lines. I wanted to show an illustration of how a lift or a dock could be accommodated within a literal interpretation of the code, providing 10 feet of setback from both property lines measured at a a perpendicular 90-degree angle. As you can see by the green area, it would be pretty difficult to achieve a configuration that fits within that literal interpretation. That being said, I believe it was with the prior property owner, there was a previous interpretation given this constraint that a dock of this configuration that has the setbacks measured of 10 feet at a slightly different location than the 90-degree perpendicular would be accepted without need for relief. The applicant has not pursued this. Again, that was a previous property owner, not the same one, but I just wanted to show some context of how previous discussions have occurred regarding how a dock could be achieved on this, even though the literal interpretation would be pretty difficult to fit something in there. Because the applicant wants to seek the jet ski lift at a greater footprint than this, again, that is why they're before you today. This is an overlay of the site plan on top of the aerial, just to provide some more site context to show how it might look. I want to preface this by saying this was done in-house. It's not a sign and seal drawing. It's not necessarily to scale, but it's just meant to provide a visual and illustrative example of how the scope of work might fit within the context of the surrounding neighbors, and then showing area where the neighbors theoretically could have their own boat lift or moored vessel or anything of the sort. And then lastly, I did want to touch on the plat. Again, this is the original plat of the property. You can see not just this one, but the one, lot 20, as well as lots north of this. There is quite an atypical configuration where these lots meet the waterway. So there are some unique challenges that these property owners have to face that the code doesn't necessarily expect or anticipate when those regulations were established. So moving on to the required findings, these are the considerations you need to make with regard to approval of this. They were more detailed in the staff report. They're here for your review. I don't necessarily want to read through all of them, but I do want to just touch on a little bit of staff analysis summary. First, the unique and atypical site conditions and lot line configuration is a product of the original plat and not a result of a subdivision after the fact or any specific action of the applicant. It wasn't an illegal subdivision or something that they did to create this peculiar situation. Second, as shown by the graphic with the green triangle, it may be infeasible for the applicant, given the atypical site configuration, to comply with minimum setbacks as required by the code. There was that alternative interpretation created, though, previously. Waterway access and docking for vessels is a commonly enjoined and reasonably expected amenity for waterfront homes, including those in the immediate vicinity. The approval of the variance would not authorize the owner to store a vessel, whether it's a jet ski or something else. In their application, they refer to it as a jet ski, but future owners, etc. Doesn't matter the vessel type, in such a manner that the vessel encroaches beyond the footprint of the platform lift. The vessel must not encroach beyond the property line and or the defined riparian rights line. We asked them to add a note to their site plan confirming that, in the event this setback is approved with a 0-foot setback, nothing that sits on top of it would encroach further than that. And then lastly, it is the applicant alluded to this in their presentation, where they feel confident that there is still, access to this lift, given that the jet skis have a smaller footprint. But it is the responsibility of the applicant to ensure that the design of their proposed lift remains functional and accessible in the event that a neighbor pursues construction of a lawful and compliant boat lift on an adjacent property. So they have to reasonably expect that an applicant next door could come in tomorrow with an application to build a boat lift or dock that doesn't require variances, and this doesn't really have anything to do with that necessarily. Lastly, some considerations for you to ponder as you evaluate this request. Is the size of the proposed lift the minimum necessary to maintain reasonable use of the land? It's for you to consider. Could an alternative design with less footprint still achieve the same functionality? The applicant referenced that this particular proposal is intended to accommodate 2 jet skis. Could hypothetically, a proposal that accommodates 1 jet ski still be a reasonable use of the land? Is a lift essential to maintain reasonable use of that land as well? The lift component relative to just a dock with a moored vessel. And then would the encroachment create an injurious situation that infringes on the neighbors and or the public's right to access? Or does the proposed scope mitigate potential issues such that the desired outcome, which is a reasonable use of land for all parties, still maintained? So that's all sort of another way of describing the applicable criteria, just trying to summarize it for you as you deliberate. These are your options moving forward. You can move to approve, move to deny, or move to continue with direction. I'm happy to answer any questions. Yes. And as I'm flipping over, I want to just confirm that there was some correspondence we received from some neighbors in the area that should be available to you for your consideration as well.
So,
Sorry, I passed it.
right. So for the record, I'm Anthea Geniotis, Development Services Director, and this analysis in terms of what could you do given the really odd lot configuration was me. So I just want to make that clear. If you have questions, it's me. And the issue is that we require setbacks for a number of reasons. And when it comes to construction of docks, finger piers, boat lifts, all of this, the code is intended to ensure, that we're mitigating impact, both visual impact and then sort of the space to move around between properties. And so that's why you comply with the side setbacks of your zoning or a 10-foot minimum, whichever is less. And so trying to establish on this odd-shaped lot what structure could be built that would provide that 10 feet of separation from the neighbor is the diagram that you have in front of you. Typically, the way that, go to your next one, the way that we, or the one with the little triangle, yeah. Typically, we just sort of visually, lots are normally rectangular. They're not usually these strange little corners. Although this area has multiple instances, I think, of those on the corners, whoever plotted the area. So we typically just visually extend it and then pull them in from either side. When somebody can't meet those setbacks, that's when they're coming to this board for review. But to be clear, the intention of setbacks is sort of multifaceted. You're trying to ensure you're not visually impacting someone's review, but that ultimately that there's a navigability that can be achieved. And clearly not every lot is created equally and can accommodate the same intensity. So I'm here if you want to have questions specifically on that. So thanks.
Thank you. Does anyone from the public wish to speak on this item? Please come forward.
Good evening. My name is Gene Perkidani. I live at 710 Southeast 8th Street. I'm a member of the community in which this variance is being requested. I've sent in some pictures, hopefully that the board received. They show what a platform lift looks like. I don't know how to put pictures up. And what a typical ski lift, wave run and jet ski lift looks like. My first comment is, this is not a condition that just popped up after the owner bought the property, but the owner, in purchasing the property, was well aware of that strange situation down there that exists all over the community. So I don't know how a hardship was created, and I didn't see the presentation of what hardship is being created in the application. Second is, it's a platform lift. It's a 7,000-pound platform lift. A jet ski weighs about 900 pounds. Okay, why he needs 7,000 pounds, I don't know, but when that platform lift is up, that's a deck extension. Pictures I've provided shows a wave runner lift, a jet ski lift, that they actually make them. When you pull in, you pull right up on the lift elevates and swings onto the dock. So that would eliminate any hardships climbing up and down a ladder trying to get on it. So I believe this is not a hardship, it's a desire of the owner. I'm opposed to the platform lift, but if I'm not opposed to a normal jet ski wave runner lift that can actually lift the person up out of the water, swivel, and they get off on their bulkhead and on their dock. So I'm opposed to this variance request.
Thank you. Anyone else?
My name is Robert Sparks. I live at 839 Southeast 7th Avenue. I live on what your papers refer to as the west side. In the photographs, I'm on what they have been calling the right side, the one with the boat.
Okay, the picture.
I live next door. As for my side, the request is that rather than a 10-foot setback, there be one of just 4 feet 2 inches. I have no objection to it, and I'm here to say that. I'll be happy to answer any questions. That's my position.
Thank you.
Good evening. My name is William Randall Sellers. I'm the owner of the property to the east of said property. And I did provide a handout. It's the one that's like 6 pages long there. Just starting on page 1 after the cover sheet. I think that's been discussed already. There are different options for jet ski lifts. I'm not opposed to someone having the ability to place a jet ski in the water and recover it. But as you see on page 1 on the left, that's the platform lift, has already been alluded to. It's kind of a large deck that really kind of creates an area for someone to go out and utilize that space there. And the other 2 pictures on the right are those types of lifts where they basically lift the jet ski up, rotate back over, and basically sit on the property, on the land, and are not over the water. And I think 2 could fit there with really no problem there. On the next page, these are just pictures of my property. I have a deck right there. I have a barbecue grill and a table right there. So if that comes out, that'll be just adjacent to my barbecue grill and basically right next door with 0-foot setback. So they're looking right into my living room, right there to my barbecue grill, and it's right next door to my property. On page 3. This is an aerial view of a couple of years ago. That's the unpermitted floating dock that you see there, a jet ski dock. You can see that one even extended out well beyond my dock. But that just gives you an idea. I just put in what would potentially be a boat. I don't currently have a vessel at my property. I've had one before, and it would be docked in that approximate area. So as you see right there, there's no way for ingress or egress to the jet boat lift or jet ski lift, because if I had a boat or a boat lift in that area, there's no way to get in and out of that. The only way really is to come from the side and come in from the side instead of going straight, to avoid a boat or boat lift at my property. The next one, page 4, again shows the same thing, basically where you'd have to kind of come in from the intracoastal, go around what would be my boat or boat lift there, and come in from the side to a boat lift that would then lift the jet ski up and then rotate onto the property. The next 2 pages, I don't know if I have time to go through this, is basically the 6 variance findings, where I've just kind of given you my input to that, where conditions and circumstances that are peculiar to the land, I don't really see any. It has a very small water frontage. There is a possibility to do something there. But the way it's been proposed now, it's just an oversized overkill to kind of create a very large 7,000-pound lift that wouldn't really be necessary. Are there special conditions and circumstances that have not resulted from actions of the applicant? I think it's the applicant's request to have this oversized lift that really is causing the problems here and causing the variance request. I think there are ways to do it to where he could still have a jet ski recovered and stored without having this 7,000-pound, 160-square-foot platform right in front of his property, in front of my property. Will it grant or confer any special privileges to him? I believe so, because he's getting an oversized deck over the water that other people in the same situation in the neighborhood would not be able to have. They would just have a jet ski lift and not a large oversized deck.
I'm sorry, I just wanted to ask, are we limited in time in any
Yeah.
way? When it
Yeah.
Yes, there's a 3-minute time limitation. I believe there's usually a timer, I think, on the desk. I have not been keeping time.
Okay,
so
I'm
not sure if
almost,
it's been-
almost done. It's just the minimum requirements. I mean, basically, he could do this with a smaller lift that would still be possible to give him the same functionality. And injurious, it is injurious to me, again, with the view, lack of privacy, and then the ability of him basically not, or me to not, to dock my boat there and have any kind of interference or dangerous interaction with the lift.
Thank you.
Thank you.
Do we have anyone else? I just want to remind, I believe that the time limitation is 3 minutes, right?
Yes, 3 minutes for an individual speaking, yes. Julian, if you need an extra copy for the applicant, you can have mine.
My name is Carlos Kavanagh from 907 Southeast 7th Avenue. And I did mail in a letter about this, and most things have been covered. The only thing I really worry about is the precedent. There's 4 other properties in this neighborhood which have this odd layout. And if you approve this, I'm pretty sure you'll have at least 2 more in quick succession. Thank you.
Thank you.
Good evening. I'm the homeowner that put in the request for this variance, and the way that happened, I'm not from the area, from Chicago. We're relocating down in Florida, and the way that happened is that when we bought the home, there was a dock there in an old seawall, and it was in disrepair. So we had the dock removed, and we did the seawall along with our other neighbors in a project that met the new requirements for the King's Tide kinds of
Sorry to
heights.
interrupt, but you're actually the applicant or the owner of the property
I'm the owner of
in
the
question?
property that's putting in the
Okay.
boat together.
Yeah. There'll be a chance for some rebuttal. I think it's probably more appropriate as the applicant to present your evidence at that time, and there's more for members of the public that are not the applicant or the
I
city.
see. Okay, so I'll wait.
Yeah.
Okay.
Anyone else?
So now that public comment is over, if
I'm from Chicago. I know how this stuff is.
Thank you. Sorry.
I get it. It's fine. So anyway, we like I said, we're relocating. We're in the process of doing that. We have 7 children and 11 grandchildren, and they'll come down every once in a while for a week or 2 here, especially during these kinds of times. And the idea was to just be able to have some access to the water. And when we bought the home, and it was in the stock that was in disrepair was there, and the seawall that needed to be reinforced, we did that project. We invested in that. We eliminated the dock, and I thought this would be a better solution. What I don't know much about this kind of stuff, so we hired the firm that you heard from earlier, and this is the solution that they gave us. I didn't say, hey, I'd like to have this big old deck that rises out of the water and it's going to extend my property. I didn't think like that. I was just saying I'd like to have something safe for my kids, my grandkids, to be able to get on and off of a jet ski, and it would be nice if there's 2 of them. And I know it's a small piece of the intercoastal there, and we knew that when we bought it, but we thought we could at least have that kind of access. And the previous homeowner did have a deck, but as I say, we had to remove that one because it wasn't quite right. So that's the reason for doing this. I also would like to make sure that everybody knows, my neighbors know, that we thought this would be the least obtrusive way of being able to bring this to a discussion, rather than me going over there and discussing this with them in a way that said, hey, I'm lobbying for you to be able to do this. And I didn't want to put anybody in there any undue pressure to think that they had to be nice to us or anything like that. And rather just, hey, look, if you object to it, that's fine. It's reasonable. I understand. One person has given his objection and another has not, and for different reasons. I understand all of that. So my primary concern here is long-term coexistence with the neighbors and being neighborly and getting along and all the rest of that stuff. If it comes down to the point where we can't have anything, I'd rather have nothing than have discontent in the neighborhood. But if there's other options, I can go back and rework it with my contractor, but this is the highest and best option that they presented to us. That's my statement, I suppose. Okay? My name is Rob Filio.
Thank you. Okay.
You gotta go like this when you say it.
Anyone else in the rebuttal cross-examination section?
Just want to make sure, because we had two people for, it's rebuttal cross at this moment. I just want to make sure, since we had two individuals speaking for the applicant, that the applicant is finished with rebuttal. Okay.
Okay, so can I ask a question if I could? So that platform that is shown on that drawing that goes all the way to the 0 setback line, that is a solid platform that is always projecting out from the property, correct? It's there all the time.
Yes, yeah, it's not going to go extending to that, past to that point. It's just safe.
It just goes up and down.
It's up and down, yeah.
And can I put some lawn chairs out there, possibly, safely?
No.
No.
You have your jet ski, you place in this way, you only have enough space to walk, to get on the jet ski, and get off, and then get off. There's no other space there. Like there was a picture of the guy who was showing us that's, like a scene. This is the oversized. It's much bigger. This is the minimalistic one. That's safe for the people to walk around, for the kids to walk around. And there's not enough space for any other addition to that. You can't use it as an entertainment center. Center. It's just strictly to use to get on and get off. It's like a catwalk. You know how people have a catwalk on the boat lift and stuff? You place on it's just to get on and get off. That's the easy access. So especially where you have wake water comes in and out. And they had like the guy who was just say the flip around. Like see like these two pictures that he showed. It's a lot more dangerous. This is best if there's no wakes at all. This water has to be completely flat to the point where they just can get put up. You can grab hold. It's for able-bodied person. If you have injuries, you have kids, you have vision, it is not safe. This is the last option, the last resort. You do not want to go for that because it's not exactly safe. Because this one you could cause sudden death, and it just creates a lot of issues, especially where you have to flip over. You take away their dock space, their cap space. They have no way to walk around because it's taken. Especially you have to have two of those to store. They have the like an elevator lift without the platform, but you still need a catwalk. You have to still a way to get on too. The problem will still be there. We have a range from 5,000, 7,000, 10,000. That's a smaller lift. That's the smallest lift that we have offered for an elevator platform. So usually we give it a standard 7,000. That's our recommendation. That's strong enough to stand any hurricane, to stand any water wakes. And the best option, because we get jutting, the beam directly into the ground, we can make it vertical. And so that way you don't have to bring the barge in, you don't have to bring any boats in or anything. So you can do everything for the property owner and then start straight down. And everything comes down here and it does not impede any navigation issues and we're very right line. So, and so some people are saying they have privacy issues, and is that mine? Yeah, right, just really quick. I'm sure to clarify that just give me this. If you look at it, if you stand on the edge, you can see the neighbors on your left side clearly. It's not much of a privacy issue. The person has a deck that sticks out and they can look into his property. And he said he also has a boat lift, so why he should be able to have a boat lift installed at his property and you deprive our homeowner, our clients, why to have a boat lift? Because it's the sizes of the white line, because the shape of the property that happens to be existing prior to the way the formatting plan is. So that's why we try to give the best option. We went through many different options. I was talking to the city. I said, hey, what can we do? So the best way is just request a variance to be waiver for that area, to be safe for all the kids. That's you have grandchildren, and you don't want them to fall in the water. That's the major concern, is the safety to get in and out. Because the platform that goes in the water is waterproof, so it can handle all those conditions.
So I have another question, if I could continue across for a minute.
Yes, sure.
Some of the neighbors discussed a boat lift that would would be able to remove the jet skis and move them onto, I guess, the property. So you explored those and just generally don't recommend those?
Yeah, I don't recommend it because it has 24 feet of Yeah, we are saying where you turn the jet ski space, you have to turn this way. So that jet ski has to go somewhere. And the jet ski is 10 feet wide. If you flip all the way through, you already lost 20 feet. And plot the space between those two jet skis, you have basically had no waterfront property. It's just taken by the two big jet skis. So it's like...
So to protect his view, you don't think the jet ski should go on his property?
They can't look at this.
So you should put them in your neighbor's view.
Yeah, if you try to move to the left side, it takes override to that person's zero cap. So you try to go to right side, it pushes to the other neighbor's side. So because the river line is angled like this way. So it's just not really much of an option. That's very, very small wiggle room. So with the platform, we can design the jet ski to park parallel or perpendicular. So for either way, if we want to come in, you could have a parallel park. You could go this way and then this out, or you can come in perpendicular. So that's the platform could go underwater and have them, navigate most safely, and they could clip on it. You get safety feature on it, so that way the jet ski doesn't float away, and the person can actually stay on the decking area until the platform lifts out of the water.
And then I think the only thing we wanted to show you is, and Julian will put the graphic up again, is that the plat of this neighborhood, another comment from public comment was that this lot is, this condition reoccurs throughout the neighborhood, and we wanted to show it to you. And that's this lot. You can see lot 20 has the same configuration, lot 12 to the north, and then it mirrors again. So again, every situation is unique, but this is, if the lot configuration is the justification for moving this forward, similar solutions would likely be forthcoming on other lots in the same exact configuration.
Well, the only thing I'd add on to that, and it's kind of into that precedence discussion we have, even if these lots dimensionally are the same, the type of residents that are on them, the spacing between residents, how many docks may or may not exist, there's going to be variables. So just because this application would be approved or denied, the 6 elements encompass more than just the configuration of your lot. So obviously that would be a continuing condition that would exist in multiple locations, but there's 6 elements that encompass beyond just what your lot boundaries are. So
in fact, most of pointed out that I did a quick Google search, Google map search on it with a satellite. There's 3 coves, so there's 6 properties with the same similar issue. They are the corner lot. They have a very small waterfront property, like 20 feet, 24 feet, 25 feet. So if you deny, you also let them know that it kind of put them in a percentage that they can't have both live ever. While everybody else have a pleasure, have a right to have them on both live, to bring their private vessel out safely. What's to say about the dock? The dock requires the same setback. That is a neighbor setback. It puts them in a similar situation. It's not a very common situation like a finger pier or a finger dock where out in the waterway there's a lot of houses, but this is a very, very specific circumstances. There was such a tiny water frontage. There's only like 6 houses in Delray Beach has it. Especially when you have a little dead end canals, then typically have a bigger edge because they're shaped differently. But in this situation, this particular one, is such a sharp turn, it's a sharp L shape. It doesn't have that much of wiggle room to have the boat lift that we can fit with better setback waivers. Some places you can have like 5 feet. It's just better. But in this case, we don't have any wiggle room. So it's like 0 feet setback, and the other one is 4 feet. So it's a very, very small wiggle room for us to try to have them to just get in safely for the kids, for anybody else to be able to gain access to it.
Anything more from the city?
No more from us. Yeah, we're good.
Thank you. We'll be moving to board's discussion. Maybe this time we can start from the left. Ms. Ramirez, do you have any questions?
There is a solution, right? He can have a lift that can swivel around and park it. Am I correct? Instead of the platform, he can have a jet ski lift.
Yeah, so that option is available. I'm not an expert in sort of dock functionality and design, so I don't know if there's legitimate concerns to installing that, but that option is available. So I'd have to see a plan, and it would have to be reviewed by our building division to determine if it's actually feasible to install it. But they're certainly available on the market, and they could explore that if, in the event that this was denied.
I do understand that.
And I believe the applicant's testimony said that, in their opinion, those aren't safe to use. But again, I'm not an expert, so I can't corroborate.
He's saying that it's not safe to use for the kids and whoever is using it. But I just really think that this platform is it can create other accidents from around the boats around it. It's extending. Is out. There's a picture. Yes.
Yeah, I mean, I don't confirm or deny what you're saying. I think your question is valid. We're not going to necessarily confirm that.
My question was that there was another option besides not using a platform. He can use a jet ski. That can be an option too, right?
Yeah, sure. I mean, I think there are other options. They could explore a different size platform. They could explore a different mechanism. Again, I don't have full sort of menu option of what is feasible, but they could perhaps clarify that if you're looking for more information.
Thank you. A few questions. So, to the city, can you discuss the Department of the Army's approval for this? How relevant that is to the discussion at hand?
Yes, so the Army Corps of Engineers and Department of Environmental Protection, I don't have the letter in front of me, but it was included in backup. We have it here. Those reviews are required for any structural element that extends into the waterway as part of the building permit process or prior to that. They're looking for their own set of rules and regulations to determine that it meets their federal requirements and then the state requirements. Approval or denial of this specific variance request doesn't absolve them responsibility to comply with federal state regulations. They're sort of independent of each other. They would still have to comply with all matters of federal state regulations as well as local building regulations, etc. This really is only a matter of that specific setback regulation and how that's reviewed, if I answered your question.
Yes, thank you very much. Second question for the city. Can you help me understand the difference between setback provisions in the law and riparian rights? Do they coincide? Or are they independent of each other?
So they're independent rights. So I'll start with that. Riparian rights don't talk about, to my knowledge, setbacks. It's a specific list of 4 rights. It's the general use of the water adjacent to the property, to wharf out to navigability, to have access to navigable waters, and the right to accretion. So can setbacks interplay with your rights to access your water and be impacted by those 4 rights? Yes, but they're not necessarily reliant upon each other. So one is a set of regulations that the city adopted to be applicable to all properties. And in instances where those regulations don't allow for the reasonable use of the land or need to be addressed, that's this process, the variance. Because even if we create an amazing set of rules, there's going to be instances where there needs to be flexibility. So that's really the setbacks. The riparian rights have a little bit of overlap. They're not absolute. A riparian right doesn't grant somebody to do whatever they'd like to do. So they may have these rights to access water, to wharf out to navigability, dockage. But that right does not come at the cost of injury to other people's rights. So that's where you may see some overlap in our elements. One of them is injurious to the neighborhood. So even if there's a riparian right to access that water, it doesn't come at the cost or injury of the neighborhood.
Thank you.
And I'll just to follow up on that, I'm grateful to William for discussing the riparian, which talks about your use and your ability to navigate on open water as a fundamental right. That does not overshadow the placement standards for the structure that you're attaching to your land, which then, has a set of standards for placement. And then that's part of why there's a determination on if something is going to impact life safety, navigability, things, anything like that, that it comes to this board, as opposed to something else. Like, I don't even want to give an example, then the applications will flood in, which would then go to commission because it's not that sort of critical consideration of relief. So.
Thank you. Final question for the applicant, please. Mr. Figliolo, so am I correct to understand that you're looking for a jet ski or two, or are you looking for potentially a boat? Do you want additional optionality outside of jet skis for this application?
We just wanted to have a jet ski or two for the kids to be able to use to have access to the intercoastal. And that's kind of the plan we had when we first saw the house and we were looking at buying a home. And they did have this dock here, and they did have that type of thing. They had the floating ones, that you have on the poles. That's what they had. They had that in place. And so we figured, okay, well then that's part of what the deal in buying the house. And then when we went and we saw this contractor that rebuilt the seawall, with the buttressed, walls and everything else, and improved the seawall, we said, okay, this looks like it can handle even something better than just one of those floaters. So what do you think? And this is the solution that they came up with. And it's not meant to be, something we end up sitting on, or we have a little grass panel behind it. That's where we have a couple of Adirondack chairs. It would sit there if we were going to look at the water. The jet skis would just be sitting on this platform.
Thank you.
Thanks.
Thank you. Can we please go to 2 slides in cities presentation? One was with green area shaded, the other one with this gray rectangle. There you go. So I just want to make sure that I understand the difference between this one and the following one with this gray rectangle. Are both of these different interpretations of the law, but both of them are permittable by the law, yes?
So the LDRs, section 7.9, that have this actually have different standards for docks, finger piers, dolphins, and boat lifts. And then the boat on the boat lift, just for fun, because the vessel on the boat lift cannot be closer than 10 feet to the neighbors. So that's part of why you'll see the note on this platform that says the vessels that are going to be stored on this platform are not going to overhang. So because part of what happens with boat lifts, and again, I'm also not an expert on docks and other things, but if you have a lift that can have a boat and you've positioned the lift in such a way that you have a 25-foot vessel on it and you are in compliance, you're not overhanging your engines and your boat too closer than 10 feet from the property line, which gives your neighbor then 10 feet from theirs and there's room, you go and buy a bigger boat, you're not getting a different building permit You're not coming before the Board of Adjustment. You just bought a bigger boat that lift happens to be able to handle. Now your 35-foot boat has put the vessel too close to your neighbor. When I tell you that these things are complex, they are. So this is not always an easy thing. So the code says you can't be closer than 10 feet. When you have a property line shaped like this and you extend the 10 feet, that's when you get the green, triangle. But you can also figure out how to put a dock that might be in there that could be 10 feet from the neighbor, I guess, to the left versus to the right. Like, we're trying to figure out how to give everybody some way to access the dock. But again, this was a previous owner, not this owner. I think this was a static dock, so it wasn't a mechanism that was going up and down. But honestly, it's been a while, I don't remember. So we were trying to figure out how to position infrastructure that would not impact the neighbors on either side and still, but it wasn't a lift and it certainly wasn't picking up jet skis, so it's a little bit different.
If they wanted to go with this option, would there have to be any variance, or that's...
For a dock, it would probably be okay, because then if the boat is in the water, it's moving. It's not subject to the same setbacks as something that's picked up and is sort of a permanent visual impact to the neighbors. And so it depends on what I hate that I always give the answer, well, it depends, because it kind of does. But it does depend if that's a dock versus a structure that is going to then have a vessel on it.
Yeah, sure. Yeah, I also want to just add that the interpretation letter where this is referencing, the gray area has a sort of footprint of 5 feet in depth off of the seawall, which is the maximum allowable for a dock. A boat lift can theoretically go up to 20 feet. It's just a completely different set of circumstances, different set of regulations. So this specifically was for a dock, given that if you were to literally interpret the code, you could not have a dock because that green space is not functional. But again, that was just more for background. This is a completely different request because that was for a dock specifically. This is for a maneuverable boat lift that can go up and down.
Was that ever shared with the applicant?
Was that
fact that was considered in the past ever shared with the applicant?
I do not know, to be honest, because I don't know what they were privy to when they submitted the building permit. Ultimately, this got flagged in building permit, and that's when they came over to apply with us for the variance request. So I don't know if they were aware of this option. Yeah.
Do you want to reflect on that?
I just wanted to explain that the previous owner had something very much like this, and a floating thing for his jet skis that went on the end of it. And the jet skis have extended where the platform is now, the floaters. Now, that may be part of the same problem, to my neighbors, but that's the way it was, and that's the one that was in such disrepair we had to take it out. Okay.
Thank you. I don't have any more questions. Rich?
I've a question for the city. If they were to do, the previously installed floating jet ski platform, was that subject to any LDRs?
Yeah, so to the best of my knowledge, a building permit would be required when you're having permanent structural elements. So if they could attach a floating dock, floating device that could affix to the existing seawall, I don't necessarily know if they would need a city permit. They may still need permission from the state or the federal agencies to have something on the waterway, but I believe if they needed to install any sort of permanent fixed structure to then attach the floating device to, that would definitely require a permit, and it would be subject to the same dock requirements, I believe.
Okay, and then one more for the applicant. So you mentioned that safety was a concern at low tide if you were to do a floating dock or floating platform. What would the drop be from the seawall to a floating jet ski platform at low tide, or basically how long would a ladder need to be for someone to access the floating dock at low tide?
It has to be 6 feet ladder minimum.
Okay.
And even with the 6 feet ladder, probably wouldn't barely be touching the water at low tide. So, and the floater platform tends to be the same size as the platform that we're proposing. It's just standard platform sizes because that's just where you put the jet ski in. They're 10 feet long, 2 pilings. So it's the floater platform is still extended to the same area. The only difference is the platform lift stays where it is. It's not going to move. It's not going anywhere. The floater platform, bad storm, wave, whatever, PVC pipe breaks, it drifts. Happens before. We don't recommend anybody who lives close to and goes closer that one because it's higher risk. It's too big of a risk, especially with the low tide. If it's a higher water closer to the cap, we could get away with it because you don't need a big ladder. If it's not a big draw, it's easy to access. But if it's a huge 6 feet difference, we always recommend a platform, which is a much safer option.
Okay. And has this platform, and maybe this is for the applicant and or the city, has this type of platform been approved elsewhere or utilized elsewhere within the city?
Yeah, we have a lot of different options. We just got one approved 2 days ago for the city commission for the chicken platform. He has the floater dock, same situation. He lives in the edge of the intercoastal, the high wakes. It was damaged his jet ski, so we had to get it replaced. And he already had his jet ski. He just moved it to the other side. It's out of the water. So we got that approved by the city commission.
And
Okay,
just to
but,
clarify.
But to be
yeah,
clear,
yeah.
that application was for a lot that
Mm-hmm.
had, I believe it was 190 feet of frontage. So it wasn't that's why you didn't see it. It went before the board because there was a boat lift and they wanted a jet ski, so they wanted to waive the one boat lift to allow 2. However, the side setbacks to the adjoining neighbors were more than twice what they required to be, I think, roughly. They were over 20 feet. And, the issue here isn't the mechanism, it's the positioning of the mechanism and the potential impact on the neighbors. And I think you have to look at the diagram you have with if the neighbors have docks that are positioned legally, is it still navigable?
Well, and the only thing I'd like to add to as well is that process was a modification of standards, and the criteria was whether the requirements of the dock section would not be feasible or would constitute a hardship, and provided that a modification would not endanger public safety and welfare. So it was only 2 findings associated with granting that request, and those 2 findings are maybe similar to 1 or 2 of your elements, but you have 6 elements that are different. So yes, that was approved, but it was approved through a different process with different findings. So I would just caution the board to rely upon that as evidence to support variance request, given the differences in how that is evaluated.
Yeah, it was more just to learn about the usage of it and utilization of it throughout the city. But I have no further questions.
Yeah, I understand the applicant, is concerned about the safety of his children and grandchildren. But is there anything that alleviate or anything that could be done for the privacy for the neighbor? Because if it's not going to happen there, it could happen maybe a few years down the road somewhere else in the area. Is there anything that could be done so he doesn't have the problem of, like you said, people looking inside of his house? And I don't know.
Directing that to the city or to the applicant? The city, I don't think we would. It would be up to them to determine if there's a solution.
I'm saying. Like, who would be determined up to?
Yeah, it would between the two property owners. What would be sufficient?
But is there anything you can do with the design that would give better privacy
Could there be a screen or something,
Something,
put on that
yeah.
side?
Could something,
Again, the platform is solely for the jet ski. It's not used for any entertainment center. It's not used for anything. There's no way people can lounge around the jet ski platform because the jet skis takes up most of the space. There's a little space of walking in. So basically, if you look at the property, all you're going to see is two jet skis. You're not going to be able to see people there because they're have their own behind the bushes. There's a trees and bushes there. They're behind those things, so it's not like they're looking at each other. They just look at the jet ski. As well as if you go out there, you see it. You see a boat left there, and you see a dock there. It's just like it's the same normal view as for everybody else. So if you go on the homeowners on the north side, you look down, you see a jet ski and the green grass and the bushes. You're not seeing the house or anything.
why, I'm sorry, excuse me, but why is he saying that he doesn't have any privacy, that if he's barbecue or if somebody, you can look into their living
The
room?
main concern is people
I'm sorry.
walking specifically onto the platform
Okay.
and lounge around there.
All right.
But it's not designed for lounge. It's not an entertainment center.
Okay.
It's just strictly a boat lift. That's why they're designed for it, to lift just in case jet ski out of the water. It's designed for that. It's not designed to be lounging around. It's not a pleasure. The deck, that's a different purpose. It's not designed for those things. It's not built.
All right,
Right.
thank you.
I can't make any more input, right? That's not allowed.
Yeah, but public comments closed, so this time it's just board discussion. Yeah.
So, thank you.
Do we have any more questions? Anyone?
I have one more, if I may. Just to clarify, sir, who's at the podium, I'm sure I don't know your name. Okay.
My name Akbar.
Akbar. Okay. So just to be clear, the 7,000-foot dock that's you're proposing, right, is the minimum requirement for these two jet skis? Is that what your position is? This couldn't be a 5,000-foot dock or a 3,000-foot dock? Is 7,000 the minimum as per your professional expertise?
Well, the 7,000 pound is just, they all have the same arm length. Doesn't matter, 10,000, 7,000, or 5,000. It's 12 feet wide. It doesn't really matter. It's just a change the specification. It's the strength. It's how much you can lift up. But the arm, the 6 out, is the same. That's the request of the waiver is the setback. It doesn't matter if you go for 5,000, 7,000, 10,000. It's 12 feet up on all of them. It's all the same. It doesn't really matter. So if you go to 7, because that's the average. Because if you want to go for 3,000, it's 10 feet arms. The jet ski will stick out there, it's going to fall backwards. So you need something that's long enough for the arm to have the jet ski stuck over there. So that's why we're 7,000. It seems like it a lot, but it's just really the arm, the standard the factory makes. They have a 10 feet arm, cradle arm, and then have the I-beam arm with the I-beam and the cradle that holds it. That's roughly 2 feet with it mounted onto the cab. So that's 2 feet plus 10 feet, and the deck board just goes on top of it. So most people have like a bunk, or some people have a catwalk, and this is just happen to have a platform. It's a square box, but it's still within the end of the arm, and the platform goes right there. It's not going to go standard. We're not building any more further. It kept it as short as possible, but due to what modification that they have.
Thank you.
We're going to move on to board order.
Okay.
Does he stay in that room or he has to vote?
No, he has until the item's concluded. So.
Yeah. Oh, okay, sorry.
No, it's fine. So this is Board of Adjustments final board order for file number 2024-028 at the Board of Adjustments January 18, 2024 meeting regarding the address at 825 Southeast 7th Avenue. The request is consideration of a variance to Land Development Regulation 7.9.11B to reduce the setback for a jet ski lift with the vessel in its raised position to 4 feet 2 inches on the west property line and 0 feet on the east property line. Pursuant to Land Development Regulations Section 2.411A5, following consideration of all the evidence and testimony, the Board of Adjustments for the City of Delray Beach finds as follows. 1. That special conditions and circumstances exist which are peculiar to the land structure or building involved and which are not generally applicable to all other land structures or buildings subject to the same zoning.
Richard Kasser,
Yes.
Seth Mitchell,
Yes.
Aura Ramirez,
No.
Brenda Cullinan,
No.
Alec Hayes.
Yes.
2. That literal interpretation of the regulations would deprive the applicant of rights commonly enjoyed by other properties subject to the same zoning.
Richard Kasser,
Yes.
Seth Mitchell,
Yes.
Aura Ramirez,
Yes.
Brenda Cullinan,
Yes.
Alec Hayes.
No.
3. That the special conditions and circumstances have not resulted from the actions of the applicant.
Richard Kasser,
Yes.
Seth Mitchell,
Yes.
Aura Ramirez,
Yes.
Brenda Cullinan,
Yes.
Alec Hayes.
Yes.
4. That granting the variance will not confer onto the applicant any special privilege that is denied to other land structures and buildings under the same zoning.
Richard Kasser,
Yes.
Seth Mitchell,
Yes.
Aura Ramirez,
Yes.
Brenda Cullinan,
Yes.
Alec Hayes.
No.
5. That the reasons set forth in the variance petition justify granting of the variance and that the variance is a minimum variance that will make possible the reasonable use of the land, building, or structure.
Richard Kasser,
Yes.
Seth Mitchell,
No.
Aura Ramirez,
No.
Brenda Cullinan,
No.
Alec Hayes.
No.
And 6. That the granting the variance will be in harmony with the general purpose and intent of existing regulations, will not be injurious to the neighborhood, or otherwise detrimental to the public welfare.
Richard Kasser,
Yes.
Seth Mitchell,
No.
Aura Ramirez,
No.
Brenda Cullinan,
No.
Alec Hayes.
No.
So the board as a whole has determined that the following elements were not met for the variance application. 1, that the special conditions and circumstances exist which are peculiar to the land structure or building involved, which are not generally applicable to land structures or buildings subject to the same zoning. That the literal interpretation of the regulations would deprive the applicant of rights commonly enjoyed by other properties subject to the same zoning. The granting of variance will not confer on the applicant a special privilege denied to other land structures or buildings under the same zoning. That the reasons set forth in the variance petition justify granting of the variance, and the variance is the minimum variance that will make possible reasonable use of the land, building, or structure, and that the granting of the variance would be in harmony with the general purpose and intent of existing regulations, would not have been injurious to the neighborhood or otherwise detrimental to public welfare. Since the board found the elements were not met for those 5 requirements, it would be appropriate for a motion to deny at this time.
Motion to deny.
Second.
Who made the motion?
Ms. Ramirez, and then seconded by Mr. Mitchell.
Richard Kasser,
No.
Seth Mitchell,
Where affirmative is in support of the motion, right?
To deny, yes.
Yes.
Aura Ramirez,
Yes.
Brenda Cullinan,
Yes.
Alec Hayes.
Yes.
Chair, that concludes all the board orders for item 8B.
Should we call Mr. Schlesser now?
Yes, at this time, Mr. Schlesser can join us.
And now reports and comments section. Do we have any comments from the staff?
Thank you all for volunteering your service, and just as a reminder, the regularly scheduled next meeting is February 1st, and to be sure you're checking your email for any information. If there's no cases, we'll cancel. But that's all I have for tonight. Thank you.
Thank you.
No reports or comments from our office, Chair.
Any comments or reports from board members? Right, thank
I have a
you.
comment
Yep.
very quickly. So I was thinking a lot about this with regards to our first meeting, my first meeting last time, the potential for amending the law to allow for a motion for rehearing or for reconsideration before an applicant would go to was it civil circuit court? I think it might be appropriate. I would be in for that type of discussion.
Wait, isn't that
Yeah,
the way it is?
so you're not necessarily saying for a specific application, but at the last meeting, you felt that maybe there should be a discussion on whether the appellate process should follow city commission pathway versus the immediate return or the immediacy to proceed to circuit court.
I think so, since we're the last stop internally before we go to the courts, that we have in the law a chance for an applicant to have a motion for rehearing or reconsideration. Even with the Supreme Court, there is that type of...
So this board does have the opportunity to make a motion for reconsideration. Those are in the local rules.
They are, okay.
So this board has that right. Now, the difference between this board and most of the other boards in the city is that the applicant, if they're denied, cannot appeal their denial to city commission. It's a different standard and different process. So they would actually be appealing to the court system itself, not the city commission. I can't recall whether that's statutorily required, so I would need to look into that, whether the board could even suggest or have a discussion on changing that process. But the entire time that I've been with the city, and I don't know if Anthea has any historical knowledge on it, but the variances have always, with this board, have always required the appeal.
I was on it a few years ago and I was able to appeal. I remember that.
So, and I'm sorry, just to circle back to make sure that, especially for new board members, the motion to reconsider is limited to somebody who voted against the approval.
Right.
So there's that as well, that, if one of these cases are keeping you up at night and you really feel like you were the deciding vote and you're reconsidering, your vote, then that has to be made by somebody who was... How do I say that?
Yeah,
right
so,
on the... Can you explain that a little bit?
Yeah, I have the local rules open, so I have the actual section. So I'll read some of the language and maybe provide a little bit of direction too. So an action of the board may be reconsidered at the same meeting or the very next regular meeting. A motion to reconsider can only be made by a member who voted on the prevailing side of the motion and is debatable. Such motion shall not be entertained if the approved action has been partially or fully carried out, if a contract from the party of the contract has been notified of the outcome, if an ordinance or other action taken after a required public hearing, or the vote has caused something to be done that is impossible to undo. So there are certain circumstances in which a motion for reconsideration cannot be made by this board or the city commission. That's under the local rules. Motions for reconsideration and a motion to reconsider should typically only be used or considered if there is evidence that would have made a substantial difference and that evidence arose after the decision. And I'm speaking generally, so there may be other circumstances, and if they arise, we can talk about them. But if there's evidence that the applicant that was available, but they didn't present for whatever reason, or if the board composition changes, those aren't valid reasons for this board to reconsider something that they've an action that they've finalized. So it should be used limited. I think maybe once it's been used by city commission. I could be wrong about that. Generally speaking, I can't think of any application in which it may have met that heightened burden for this board to really reconsider. But just like every application, it'd be a case-by-case basis, and if a board member would like to discuss it, we can definitely have that discussion at the time.
Is there a rule that this motion will have to be brought in the following meeting? Is there a time period?
So generally, yes, it says at the same meeting or the very next regular meeting. There are some exceptions at the end of the local rule. Generally speaking, I don't think they would apply to this board. So if that motion would need to be made at the same meeting or at the next meeting. And an example that I think might be worthwhile to watch, and I don't remember if it was maybe 2 meetings ago, board member Miles actually said that his understanding or interpretation of a fact or element that had been presented, he got clarity and thought that he actually interpreted that wrong and thought that it might be appropriate to revisit. There wasn't a consensus of the board to do that, so that did not happen. But that might be an example where there's a reason that a board member may want to discuss, reconsideration of something that was ultimately denied.
I think that was a meeting from October 5th, if I remember correctly, and it's on YouTube, right? If anyone is
Yeah, all the meetings should be on YouTube. And the city's website. So they're available there. Chair, your memory it must be better than mine.
Because I saw it today.
Okay. Oh,
it's not that good.
So that might be an example that at least would warrant debate or consideration.
Or if I send you all a letter that says, I gave you testimony that the setback was 10 feet, and it turns out it was only 2.
Yeah.
And then you might be saying, like, well, I might have voted differently had you given me the right information, which that's just an example.
Does it also
You would never give us some correct
information. It would never be that far
Yes or no
off.
on the
But
6 items. I know you have to be on the prevailing side of the...
Okay, so the 6 elements that we read are findings. They're not a board action. The board hasn't taken action on the applicant. It is evaluating the 6 criteria that it must find positive support for in order to grant the variance request. So the action is actually that motion that comes after we go through those 6 elements.
And this board, unlike some boards, requires the supermajority,
Yes.
which means the minute one of those findings, and that's why Mr. Bennett is really great about saying, okay, so this is the one that, or the 2, or,
And I would just clarify.
because it's important on the record for us to know
Yeah.
why the board said no. Which finding did it not meet?
The land development regulations do not use the word supermajority. They specifically say that 5 members are required in order to grant a variance. So, as you know, right now, the board only constitutes 6, and we have 6 members here. And if my math is right, I think a supermajority under that would normally be 4 out of 6 instead of, would it still be 5? Sorry, we did a long exercise on the number of people, which is why we specifically, when the Board of Adjustments language was modified, the board composition was modified from 5 regular members and 2 alternates to a full 7 regular. We kept it simple at 5 members so that we weren't here trying to figure out what's a supermajority of 5 people or 4 people or 6 people or 7 people. So it's a defined number. So if there's only 5 people here, that needs all 5. There's 6 members here, needs 5 out of 6. If there's 7, still 5 out of 7.
Okay, I think my point was, and I understand everything you just told me, so thank you, was regarding an applicant wanting to make a motion for reconsideration for the Board of Adjustment denying their variance request.
Yeah, so even we've seen, I think, at least 2 of these in the last 6 months, and the applicant will come to public comment, and they'll present a reason or that they believe the board should make a motion for reconsideration.
I see.
They
Okay.
do not have a right to a motion for reconsideration. It's not an application, so that is a difference between what would normally be an appeal to city commission through the other boards versus, the relief here is discretionary on the part of this board to decide whether it even honestly wants to discuss the motion to consideration, and then after discussion, it would still require a vote, a second, and a roll call, and if it were to fail, then there's no reconsideration.
Thank you. Yeah, I was just thinking about the first case. The applicant's building a whole house, and he's not going to be able to have his boat dock. So, if I were him, I would be up in arms and trying to find the right way to get that approved. So,
Any more comments? Thank you, everyone. The meeting is adjourned.
I do have a request. Can we have a picture with all of us here on the board? Is that possible or no?
A favor.
I don't know.
Okay.
Does